Mark, how are you?
You're leaving now?
Mark, this is a discovery down here, I think. The state, I believe, is not.
Judge, this is an old colleague of mine, Mark Lambert. He represents one of the banks that Bruce Cobb is trying to subpoena records from.
Colleague?
Yes.
Of yours? I don't know if that's comment on me personally or.
He's he looks fairly young, honestly.
Well, when y'all stand close to each other, yes. He does. Hey, Bruce, a couple of things here that jumps out at him. As you know, this thing's 4 years old.
Right.
It's too old. We got to move forward.
Right.
For years, that's how long this case has been dragging. Think about that: witnesses forget, evidence ages, and the system creaks. But here's the kicker. The defense still has not gotten the discovery they say they need. So the big question is, are we pushing for justice or just pushing paper?
How are we going to do that?
I'd like to get that discovery so I can defend this case.
Well,
What's
okay, so let me respond to that, Judge. If his contention is that he's going to utilize this discovery to defend this case, that is absolutely ludicrous. That it's the amount of loss is not even an issue in the indictment. There is no complainant listed in the indictment. That'll be his next thing he points out, which is that the complainant really recently passed away. So if this discovery is designed to determine the restitution.
Let's pause here. The prosecution says the amount of loss isn't even an issue in the indictment, but the defense is chasing financial records like it's the smoking gun. Why? Because sometimes in court, what is not written in the charges can be just as powerful as what is, especially when restitution's on the line.
And he wants to resolve this case, then yes, I'm for it. But the amount of loss simply isn't an issue. I've always agreed to a limited version of producing this discovery under the assumption that he was trying to get it to make arguments about what the restitution should be.
Well, but it's a lot more than that, well.
It absolutely is not, actually.
The fraud is an essential element.
Okay, well, how does that amount of loss have anything to do with intent to defraud? One shred of evidence case. Okay, well.
But it should be very relevant to the amount of restitution, if it is.
Which is not something the jury even determines.
Y'all through? What is it everybody wants?
Okay, Judge Mark Lambert, I'm here for Purdue Good Credit Union. I guess I'm the point of contention here. At this point, we've received a subpoena. We've objected to the subpoena for the records that Mr. Cobb are referencing. Under Section 59 of the Finance Code, the only possible way I can produce these records for Mr. Coon, whose records are being sought, is if he is served with notice and has the opportunity to object and signs a waiver. Otherwise, the financial institution can be held responsible for releasing privileged and private information and offered information. Obviously, that didn't happen. He's now passed away. The only other opportunity for Mr. Cobb and Mr. Eckert to get these records, if the court so desires and grants, is if the court will sign an order for us to provide the records to the judge for an in-camera inspection to determine the scope of the records that would be either admissible or just.
Now this is where it gets thorny. The guy whose records are being subpoenaed, he's dead. That's a legal landmine. Financial institutions cannot just hand over private records unless certain protections are in place. So what do you do when the only person who could consent is gone?
Discoverable and any redactions therefore. I don't think I can technically redact until the court says these are the records we have to produce. So we have a subpoena sitting on us that is due. I have objections that I filed with the court. I just don't know the scope of what the court will require me to produce to the party.
What do y'all say about what the gentleman just said?
Well, Mr. Kuhn was supposed to have gone and done a waiver, which we had agreed that he would sign, but he never got around to signing it because he passed away in the process. I've been a lot better than for.
We know he's passed away. What are we going to do about it? No, we can't change that. We move forward, and
Right.
we're moving forward one way or the other.
Yeah.
The passing away of an important person involved in a lawsuit doesn't scuttle what the grand jury has indicted. So we should forward.
Judge, I think you need to order the bank to give you the
Yeah,
records and camera.
Yeah.
That seems to me the proper way that
Right? Here's the turning point. The judge is stepping in to request an in-camera inspection. That means the court itself will privately review the records before deciding what can be released. It's a smart move, keeps things fair, legal, and clean. But it also slows everything down again.
this court has control over the situation, and all the parties are placing it into the hands of the court in these pretrial matters, which I think is where it needs to be. And when there's a disagreement of the way things should be, what I want from the bank is a proposed order, please, that
Probably has one.
fits with what you deem under the law is the way to proceed, that also is in the best interest of your client's liability exposure. And I can appreciate, my dad was a battler, so I will appreciate the caution. But this is 4 years old.
We should have,
It's way too old.
we had worked on an order. And I think,
I have a motion to compel discovery here back in January, from January, and then an order granting a protective order here. Was this presented by?
I think it was a mutual document drafted by Mr. Cobb and I initially to protect us until he could get the waiver signed by Mr. Coon. And I think at the end of that order, if I remember correctly, is the section 59. And it sets forth the documents that he wanted. And
Did you catch that? They had a protective order in place from way back in January. That means both sides knew this issue was coming in. They tried to patch it with legal duct tape, but with the waiver never signed and time ticking, the cracks are now showing.
and that we would be protected.
Have you seen this?
I believe I have.
Any objections for me signing this?
What's the scope of what's to be produced?
it's that same thing, I mentioned.
Well, Bruce,
When you do it, it bothers him.
yeah, because it's way broader than what we talk about.
He's always grabbing for his wallet when you're near him, Bruce, for some reason.
And just so we're on the same page, Your Honor, we're talking about a lot of records. They haven't been sifted through by the bank because we didn't know the scope. So I can narrow it down to whatever scope that the work orders or the parts will be on. I just need some guidance.
Yes, this number 2 here is the scope of what I've agreed to talk about.
I've got both Mr. Coker and Mr. Cobb's signature on this.
Sure.
That will be made a part of the record, and we have a defendant's motion to compel discovery and request for hearing of this.
Well, I think
What else?
that moved-
Go ahead. It's moved.
We already had
You
that.
withdraw this then?
Yes.
Okay, then. So what's next on this 4.5-year-old case to move it forward? What are we?
They're going
what do I
to
need to do?
they're going to submit an order.
Okay.
Yeah.
All right. Well,
They've yet to
that
tell me.
may not work, depending upon what's going to be necessary for preparation, but it'll stay there on that docket.
All right, after all that back and forth, the judge is basically saying, get me that order. Let's keep this on the docket and move forward. But will this 4.5-year-old case actually gain momentum or just stay stuck in legal limbo? Hit the comments. What would you do if the key witness passed away mid-discovery?
And it'll be at least a goal for us to reach.
Right.
To try to reach. What else do we need to do today that you need from me?
I think that's about it, Your Honor.
Okay. The state, how many witnesses are you guessing you're thinking about? And maybe
5 or 10.